If you are a commercial landlord or tenant, this video is for you. Welcome back to the AFJ Law Group YouTube channel. I'm attorney Alexis Johnson, and I'll be discussing best practices to pandemic-proof your next commercial lease. Because like it or not, businesses are moving away from the virtual model of last year and looking into brick and mortar space again, which is actually a positive because it gives a lot of opportunity for commercial landlords with vacant space with motivated tenants. The tricky part is navigating it so that you don't have the legal issues that arose last year as a result of COVID. The good news is we have hindsight going forward. So I'm going to talk about 4 post-pandemic provisions that should be in any commercial lease. Now, it's possible that you may have one or all of these provisions in your lease already, but you should still have an attorney work with you to make sure that they're detailed and thorough enough to encompass anything that could come ahead. Now, before we get started, make sure you like and subscribe to our YouTube channel so that you don't miss out on any other AFJ Law videos. And if you have questions, please reach out to my team, afjlawgroup.com, or call or text 248-266-2135. Now let's get into it. The right lawyer makes the difference. AFJ Law Group. The first provision I'll be talking about covers rent abatement, which entitles a tenant to stop paying rent or pay less rent when the commercial property isn't usable. For pandemic-related purposes, a provision might include coverage for an event resulting in a governmental shutdown, like COVID, where a tenant does not have to comply with their rent obligations under the lease until things open back up again. However, it's important to clarify the specifics of this provision as well as define the term pandemic, because if the provision is too broad, it may not be upheld in court and the parties may not have a meeting of the minds or understand each other and what the term means. Build-out protection is usually addressed in most commercial leases, but the importance of it is heightened post-pandemic. The term build-out typically applies to constructions and activities performed in a commercial building space to make it operative for a tenant. The build-out process requires negotiation between the tenants and the landlord regarding what kinds of improvements will be made and who is responsible for paying for them. It's important to note that improvements are not always paid for by the landlord or tenant, but often can be a combination of the two. Though build-out protection has always been important, as I said, it's even more so post-pandemic to protect against pandemic-related delays or material shortages. Now, it's no surprise that the necessity of cleaning protocols in commercial leases have increased dramatically post-pandemic. As a rule, commercial landlords should anticipate that potential tenants will be concerned about cleanliness and safety for their employees and customers. A savvy commercial tenant will want to confirm that the premises complies with all CDC requirements for the HVAC systems, as well as post-pandemic OSHA requirements or any other regulatory entities that govern the tenant's particular business or industry. Prior to the pandemic, many business owners paid little attention to assignment and sublease provisions when negotiating commercial leases, because it was more common to focus on rent, maintenance, taxes, and insurance, or other factors that affect a tenant's bottom line. Not surprisingly, the global pandemic and subsequent economic shutdown have now made flexibility one of the top concerns for commercial tenants. So in this context, assignment and sublease provisions are key deal terms. The first thing to understand is the difference between an assignment and a sublease. An assignment transfers all of the original tenant's rights and obligations to the assignee, or the new tenant, though both maintain a contractual relationship with the landlord and face potential liability in the event of a failure to pay or other damage. In a sublease, the original tenant will generally continue to pay rent to the landlord while the new tenant pays rent to the original tenant. The new tenant usually does not have a contractual relationship with the landlord and will have to look to the original tenant to enforce provisions of the lease. If a business owner is considering entering into a new lease, it's important to carefully renew the subleasing and assignment provisions and negotiate any necessary changes prior to signing. An experienced real estate attorney can assist the tenant and landlord by spotting issues, explaining alternatives, and negotiating to help accomplish the business objectives.